hearing in the matter of the Republic of Kazakhstan and Terra Raf Trans Trading Limited.
Mr. Malik.
Morning. I appear on behalf of the Appellant, the Republic of Kazakhstan, with my other friend, Clarissa Jones, James Ramsden, King's Counsel, Mr. Philip Korn, and Mr. Diraj Nagrani appear on behalf of the Respondent. I will finish before 12:30, and if I may, I'll just give the Board a brief outline in terms of the structure of my argument by way of a roadmap. The first part is going to cover three topics. The Swedish Arbitration Award in December 2013. I will then look at the enforcement proceedings brought in England by the Stati parties, including the Respondent, and then I will say a few words about the concept of judgment laundering. I will then turn to the legislative framework under the Gibraltar Act with which we're concerned. I will then deal with the principles of interpretation, which I think I can deal with, I intend to take quickly, and then I will then deal with the two appellate issues before the Board. That's the proposed structure. As far as the background, the award is concerned, as the Board is aware, we're concerned with the registration of 3 English cost orders made in proceedings in the Commercial Court in London. The proceedings were brought by the Statis in order to obtain leave from the English High Court to enforce a Swedish arbitration award against the appellant in England. The proceedings were unsuccessful, and the award has not and never will be enforced in England. And there are three points about the award. The first, in terms of the underlying dispute, it's briefly covered in the decisions below, and I don't propose to go into the detail, but it concerned an arbitration seated in Sweden and governed by the Swedish rules of the Chamber of Commerce. The award is in the bundle, and it may be that my learned friend intends to take the Board to it, but we say that there's nothing in the award that affects the legal issues before the Board today. The second point is that the award is a New York Convention award, and that provides, in my submission as I will develop, crucial context. The Convention is familiar to the Board. It's a cornerstone of international commercial arbitration. It is one of the most widely ratified commercial treaties in the world, and its existence is seen as one of the benefits of arbitration as a form of dispute resolution between parties to international transactions. And there are 3 points that come out of that. First of all, a New York Convention award can be recognized and enforced almost anywhere in the world. A contrast with court judgments is striking. The second point is that the courts have an important role to play when it comes to enforcement of New York Convention awards. Amongst other things, they have their own rules about the allocation of responsibility for costs when their process is invoked, but such costs are a local issue. It has nothing to do with the New York Convention, the award, or the law of the sea to the arbitration. In England, cost orders are a matter of the court's discretion pursuant to the statutory power under Section 51 of the Senior Courts Act of 1981, and are therefore multifactorial in nature. Cost reflects overall justice of the case, and it's about applying considerations of fairness and common sense. The third point to make about the New York Convention Award is that a party who has an unsatisfied New York Convention Award has a variety of ways of seeking to enforce, and the enforcement works in different ways. And this third point is important in the context of the appeal. This is because the Court of Appeal below held that Section 3(2)(a)(c), read in the combination with Section 11A, is intended to prevent what's described as award laundering. It's therefore important to understand how that might happen and how this relates to the wording of Section 3(2)(a)(c), if at all. In the domestic context, the Statis have enforced against assets in Sweden. Outside Sweden, they brought numerous proceedings where they consider Kazakhstan has assets. They've not brought proceedings in Gibraltar. In England, the Statis sought leave to enforce the award under the Arbitration Act of 1996. And if I may ask the Board to get the electronic bundle on screen, and at page 1926, there should be a reference there to Dyson Morris Rule 67.
Sorry, problem.
Yes. it's Dicey Rule 67.
Sorry, the page again, please.
It's electronic 1926.
Thank you.
Where it says that a New York Convention award shall be recognised as binding on the parties. I don't think that the rest there, but it's B, and may be enforced either by may be enforced either by proceedings at common law or under the provisions of Section 66 of the Arbitration Act, i.e. by leave of the High Court in the same manner as a judgment or order to the same effect, subject to the grounds for refusal. And you can see there at the footnote there in this rather small text, there's a reference there to Section 1012, where it says that Rule 67 requires in relevant part that the award be enforced in the same manner as a judgment or order of the court to the same effect. And this part of the rule sets out the test in Section 1012 of the 1996 Act, which is in turn based on the New York Convention, and you can see what's written there. So, and then alternatively, a New York Convention award may be enforced as a foreign judgment, and we can see that again using Dicey and Morris. And if I could ask the board please to turn to page 1931. 1931. There's a reference there to 72.1, and of course keep in mind that we're in Gibraltar, and so references to the United Kingdom and also to the 33 Act needed obviously adjustment. And then it says if a party obtains a foreign judgment by which a foreign arbitral award is made enforceable, that judgment may be enforced in England in accordance with rules 56, 56, 57, 59. And then this is the key part. An arbitral award made in a country outside the United Kingdom, to which Part 2 of the, that's not applicable, but or Part 1 of the 1933 Act applies, is enforceable in the same manner as a judgment given by a court in that country, provided that the award has, in pursuance of the law enforced in the country where it has made, become enforceable in the same manner as a judgment given by the court of that country. That's common ground that the Gibraltar Act mirrors the 1933 Act. The next point in terms of how this all operates can be seen at 1932 of Dicey and Morris. If I could ask the board to turn to that. And that makes the point to paragraph 16, well, in fact it's 16.147 and 16.148. It's really the passage saying that an order merely granting leave to enforce an award is not enforceable at common law because it is not a judgment requiring the payment of money. And we will see that that's true as a matter of enforcement under the Gibraltar Act. And then there's the distinction between an order enabling enforcement and a money judgment. And that's consistent with the civil law principle of exequatur, that was covered in the strategic technologies case at paragraph 67. And then the other reference to look at is going back at 1932 of Dicey and Morris. So in fact 1931. Which we've looked at, which explains that the enforcement of award using the 1920 or the 1933 Act is only possible where it was made in a country to which the acts have been extended and has become enforceable under the law of that country in the same manner as a judgment of a court of that country. And that's obviously the position as also under the Gibraltar Act. And that requirement would appear to be satisfied if leave to enforce has been given in terms equivalent to Section 67 of the Arbitration Act. And you can see that if we then go to page 1934, where there's a passage there at 16-154, which is the passage that I just read, and again, the equivalent provisions apply. So these acts provide another enforcement regime running in parallel with the New York Convention, but in my submission has very little practical significance where the New York Convention applies because of the ease of enforcement by which New York Convention awards are applicable. And of course, all the states involved in this case are signatories to the New York Convention.
What's the relevance of that?
It's relevant. It's relevant to the point where we come to look at the question, the second part of the question, which is whether or not the foreign judgment was given in relation to proceedings relating to a qualifying award. And it's my submission is that yes, there was a qualifying award in the sense that that term has been explained, but in this context, the proceedings were English proceedings under the New York Convention, and the fact that there was a qualifying award was irrelevant to the purposes of the English proceedings. And therefore, when you come to the second limb of my argument, I will be arguing that we are not concerned with the 3.2a C point, because we're not concerned with proceedings relating to a qualifying award. We're relating to proceedings relating to a New York Convention award. And that's where that point comes in. And that's why we submit that it's relevant to have regard to how the English proceedings were characterized. And they are characterized as proceedings relating to the enforcement of an award, not relating to the enforcement of a qualifying award. And the fact that there was a qualifying award had no relevance at all to the English proceedings. That's where it comes in. So the point here is that neither the 1920 Act or the 1933 Act could have applied here because neither has been extended to Sweden. So that's important to come into mind. And just to follow up the point that my Lord Legate made, the key points here is that the object of the English proceedings was to obtain leave to enforce the award under the New York Convention and the Arbitration Act. They were not proceedings on the award, which, if successful, would have given rise to an English judgment on the award, nor were they proceedings to enforce a Swedish judgment on the award or to enforce the award as if it was a Swedish judgment. And the second point, therefore, is that it's therefore irrelevant in the English proceedings whether the award has become enforceable under Swedish law in the same manner as a judgment of a Swedish court.
So is it your case that the Gibraltar Act sort of picks and chooses between these different ways in which a foreign judgment or award is being enforced in England in terms of whether they can be registered in Gibraltar?
It's a question of, yes, it's a question of characterising what has happened. I mean, essentially what happens in this type of treaty arrangements is that the two states get together and say, we will enforce judgments falling within these criteria. And what happened by way of the amendment was to add another type of awards, but awards meeting a certain type of criteria. Now,
some types of award are in and some are out.
Exactly, that's right. That will be my submission.
No broad purpose of can't enforce a judgment on a judgment or award. It's much more fine-tuned than that.
Well, that principle about not enforcing a judgment on a judgment obviously applies a general principle. And of course, your lordships have my point, and my lady, which is that we're not concerned here with enforcement of award, we're concerned with non-enforcement of award, and there's no question of any enforcement of a judgment on a judgment. On the contrary, we're saying there is no judgment or award. But yes, the answer to my Lord's question is correct, is that we will need to look carefully in terms of what actually is being enforced. And that comes in both at the first limit of the argument, which is the 11A, which is that it was designed to extend the type of awards that were going to be enforced, which doesn't apply here because we haven't got an English award. And then the second point, which I've just touched upon, which is that when one comes to look at the question of what is being what were the English proceedings? They were not proceedings on a qualifying award. Yes, it was a qualifying award, but that was not relevant to the New York Convention.
So it was a qualifying award because under Swedish law,
Correct.
the Swedish award is treated as a Swedish judgment.
Correct.
But what I think you're saying is that once you come to England, the fact that it's a Swedish judgment is neither here nor there. The important thing is that it's a New York Convention Tribunal award.
Correct. And just to explain, because it's not entirely clear from the papers, and just to spend sort of a couple of minutes in terms of what was the status of the award in Sweden. There was never a Swedish judgment, but the Court of Appeal reached its decision on the basis that the Swedish award had become enforceable under Swedish law in the same manner as a Swedish judgment. But that was not because of a Swedish judgment to that effect. It was on the basis of what Mr. Justice Yates was told on instructions, which we're not taking any point about, by counsel, that the award was enforceable as a judgment pursuant to the Swedish Enforcement Code, and because the award is being enforced in Sweden. And you can see how the point was made at first instance. I don't know if
Sorry, can I just ask, if the application to enforce the award in England had succeeded, are you saying the judgment would have been enforceable in Gibraltar?
No, it would have been a judgment on a judgment.
Right. So where does all this go? I mean, that's where we come back to, isn't it? Whether the costs go with that or they don't. Orders go with that.
We say that we say first of all that the first limit of the argument is that the Section 8 is not in play here because we haven't got a qualifying award by reference to the English law. And secondly, we say that the proceedings are not based on a qualifying award, which is the point that we just made. And I was just looking at in terms of what was going on in Sweden, and it's paragraph. If you're using the key bundle document, it's 109. It's at paragraph 33. I think you've got in hard form, and it might be easier to make reference to the key documents.
Well, it's not actually.
Okay, well, then
you could stick to, as far as I'm concerned, to references to the electronic bundle. That's what we've got on our screen.
It's 34, page 34.
So we're talking about Mr. Justice Yates.
Yes, it's just the reference to the Swedish Enforcement Code. Because it's...
I mean, for my part, if you give me the paragraph number in the judgment, it would be helpful.
Paragraph
I do use a hard copy.
Paragraph 33.
Oh, thank you.
But there was no issue about this.
No, and just to deal with the board's curiosity, the actual text was given in oral submission, and if we turn to the electronic bundle at 836, you'll see the council doing exactly as the judge said, making a reference to the enforcement code, and the relevant provision is there in the middle of the page. As enforcement may, subject to the preconditions stated in this Act, take place on the basis of the following enforcement titles, the arbitration award. So that's what the reference is. And there's no challenge to the position under Swedish law. And so the third point in terms of this list of points about the award that I wanted to make at this stage is the non-payment of the award. And as the board is aware, the Swedish courts have refused to annul the award, and the key decision there is a decision of the Sphere Court of Appeal dated the 9th of December. And my learned friend's written case below, in footnote 3, page 1067, refers to a Swedish Supreme Court decision rejecting an extraordinary review application and a further decision of the Sphere Court of Appeal rejecting a renewed annulment application. But as the board is aware, a decision of the courts of the seat not to annul an award does not preclude the courts of another country from denying its enforcement if it finds that that would be contrary to public policy. And as the board is aware, our case is that the award is contrary to public policy, being obtained by fraud, and it made that argument in the English court. And as the court is aware, it was the board is aware, Mr. Justice Robin Knowles found that there was a sufficient prima facie case to proceed to a trial. Of that issue, directions were given for trial, and then the statties discontinued the proceedings rather to have the issue determined. Again, my submission, it's not necessary for the board to get involved in this, but there's no decision was ever reached in England on the fraud issue. But as recorded in the agreed statement of facts, page 103.1 of the electronic bundle at paragraph 29, the courts of the Netherlands and the Belgium have refused to enforce the award on the grounds of fraud.
Sorry, Netherlands and
Belgium.
thank you.
There's a great story about all of this, but I don't think your lordships and my lady will thank me if I go into this. But essentially, this has gone a long way, both in this court and also in the courts of other states in terms of this award. Now, the next issue is the English enforcement proceedings, and this is the point that I mentioned to my Lord Legate a moment ago, where it is said that my learned friends say that the English courts are the circumstances in which the orders were made are immaterial. But in my submission, it is necessary to say something about the English proceedings and understand how they came about. They were commenced by the statties as an application under sections 101(2) and 3 of the Arbitration Act of 1996. And that was the only basis on which the statties sought to enforce the award in England. And if we can look briefly at the relevant provisions, they are to be found in the electronic bundle, starting at 1151, which is on screen. There should be a reference to the fact that the New York Convention awards shall be recognised by the UK courts. And then 101(2) is the provision under which the statties applied. In this case, it enables an award creditor to enforce the award as if it were an English judgment. 103(1), where leave is given, judgment may be entered in terms of the award. And then section 103 sets out the limited circumstances in which a New York Convention award will be denied recognition or enforcement, including where it is contrary to public policy. And that's section 103(3). And then section 104 relates to the point that the New York Convention does not exclude other methods of enforcing the award. And that reflects the aim of the New York Convention to facilitate the international recognition and enforcement of awards, and not to abrogate national regimes for the recognition of enforcement of regimes which may be less stringent than the New York Convention regimes. Now, sections 101(2) and 101(3) mirror section 66 of the 1996 Act, which apply to other foreign awards, but that doesn't arise in our case. And there's a helpful summary of the procedure in one of the decisions of Mr. Justice Robin Knowles. And if I could ask you to turn, please, to 144. There's a summary of the proceedings at paragraphs 4 to 5, and it might be worth noting that judgment was never entered in the terms of the award under section 101(3), and you can see that from the order that was made on an ex parte basis by Mr. Justice Burton, which should be in the electronic bundle, and that's of February 2014 at 115, where that's the order that was made on the application that was ex parte, and you can see that they had permission to enforce the award, but no reference to a judgment. So that's the position there on terms of how the proceedings were brought. And of course, as the board is aware, the outcome of the proceedings is twofold. First of all, the statties attempt to enforce the award in England failed. and what happened in the English proceedings is covered in the parties' written cases. And therefore, I don't propose to go into them in any detail other than the fact that the judge, having held that there was a prima facie case of fraud, directed a trial, notice of discontinuance was given. We sought to keep the proceedings alive, and then my lords, Lord Leggatt and Lord Richards, in the Court of Appeal at that stage came to the conclusion, no, there's no interest in allowing this to proceed. If they want to discontinue, they should be entitled to discontinue, and therefore not required to proceed to trial. But the order granting leave to set aside was, in fact, it's probably useful just to see the orders at 190, the electronic bundle, and you can see that that's the order that was made by the Court of Appeal. And there's a summary in terms of what the application was about, and then the order was that the appeal is allowed, and that the proceedings are discontinued, and that is the, and I think there was the undertaking I should have referred to at page 191, undertaken by the appellants not to seek to pursue further enforcement proceedings in this jurisdiction in respect to the award. So that means that they've got a New York Convention award, but as far as England is concerned, they will never come here to seek to enforce it. That didn't stop them trying to attach the assets in London, and they sought to do that in through Belgium, and that's where my Lord Hamlin came in at a stage sometime, I may not remember this, where we were seeking to effectively to get an order that the Belgium attachment proceedings were ineffective because this was an English bank account. The Court of Appeal said, no, you're wrong. This is covered by Bank of New York Mellon's terms, and therefore the proceedings go ahead. And the twist in the case is that although the order was made by the Belgian court affecting the accounts in London, the Belgian court referred that matter back to the English court, to Mr. Justice Nigel Tier, and then they made a finding of fraud, which meant that the Belgian ex equator proceedings failed, and therefore the London assets had a happy end. And of course, my Lord Jones is aware of that fund because many, many years ago, he was counsel in the AIG Capital and the Kazakhstan case. It was the same fund. So almost everyone, apart from my Lady Rose, is involved in something to do with this case at some stage. But anyway, that's the human interest point, perhaps, behind the case. But it does show the interesting interrelationship between the way that the courts have been operated in this case. Then the next top.
I see at paragraph 6 at page 192. Is that one of the costs orders that you're seeking to enforce in Gibraltar?
No, I don't believe that is a.
Right.
Was
do any of the costs orders that you are seeking to enforce have a similar set-off provision?
No.
But what would happen, well, maybe you'll come to this later, but if there had been a costs order which you say is enforceable in Gibraltar, but it was subject to a set-off of a costs order going in the opposite direction, which I think you might say is not enforceable in Gibraltar, how would that work then? Would you have to net it off, or would you not net it off?
I mean, there was an argument below in terms of the contention, well, what about the cost orders in favour of the statutes?
Yes.
And that was covered in the awards, and the conclusion was, well, that's not right for determination now. We're going to have to deal with that in due course. So there's been no determination about how the set-off operates.
This paragraph 6 is saying that they can set off their costs of the appeal against the application against the costs of in your favour.
Yes, and they will be able to do that. Yes, but as far as I can see, that if my recollection is correct, when the costs were assessed by Mr. Justice Jacobs, I can't remember any discussion about any kind of set-off because at that stage they weren't appearing, so it didn't arise.
Yeah.
Now, as far as judgment laundering is concerned, we need to look at what it means. And of course, judgment laundering is done by judgment creditors, not judgment debtors. And the judgments sought to be registered here are English cost judgments in favour of the appellant. Those orders cannot involve any laundering of a Swedish judgment, of which there is none, or the award, which is in favour of the respondent.
But it's your case that the position is symmetrical, and it applies equally to cost orders the other way.
Correct. Yes, and I'll come to that. So if we could just broadly go through what the concept of judgment laundering is, just to get it out of the way. Let's imagine we've got three countries, countries A, B, and C, and let's make country A Sweden, country B England, and country C Gibraltar. A classic example of judgment laundering is where a judgment obtains a judgment in country A, Sweden in my example, and has it recognised and made enforceable in country B, England in my example, for the purpose of being able to enforce its rights in country C, Gibraltar. The judgment of country B, the intermediate state, is referred to as a judgment on a judgment. Another language has been recognition judgment or derivative judgment. And being able to enforce the country B judgment may be preferable for a variety of reasons. Country C may not recognise the country A judgment, or enforcement of the country A judgment in country C may be time-barred, as an example. And in this case, country C, that's Gibraltar, does not allow the registration of judgments on judgments. And the Court of Appeal held that this was the purpose of Section 72AC, and you can get that from the Court of Appeal judgment at paragraph 35, which is page 59 of the electronic bundle. Now, the respondent doesn't use the term judgment laundering. Rather, it says in its written case at paragraph 67A, and this is at page 1088. It says at paragraph 67A that the purpose of section 32A is to, quote, to ensure that what is 32A is to ensure that what is registered in Gibraltar are substantive decisions on the merits of recognised courts or arbitral tribunals under their supervisory jurisdiction, rather than decisions that are jurisdictionally parasitic on a third jurisdiction. But we say that the English cost orders are not in any way using the phrase jurisdictionally parasitic on a third jurisdiction. And that obviously immediately begs the question of whether they were intended to be excluded. Now, the reasons why judgment laundering is considered to be undesirable is given in the Strategic Technologies case that my Lord Richards was in. And we've set out the relevant passage in our written case at paragraph 62, which is at 1055. And we can obviously go to the judgment itself, but it's probably convenient just to see the relevant passages. It risks what's called unbalancing the principle of reciprocity on which legislation is based, and that comes from the judgment of Lord Justice Mayles at paragraph 55, which is at 1546 of the electronic bond, where the text is found, where you can see that to interpret the act as permitting registration, the judge would unbalance this reciprocity. And so that's the first reason. And then the second reason you can see at paragraph 59 going down the page, where it talks about where it's said by Lord Justice Mayall, it's fundamental to the operation of the Act that the English court should be able to scrutinise the proceedings in the court which gave judgment on the underlying dispute in order to ensure that the conditions for registration are satisfied.
So that's a wider point.
Yes.
The point made in paragraph 55.
Correct.
And there's no reason why the point made in 59 shouldn't be the reason for subsection 2A.
Exactly. That's the way we put the case.
And the reason which is given in 55 is itself wider than
Yes.
judgment laundering.
Yes. And I think in my submission, what's going on there is that the court should be able to scrutinise itself rather than effectively being to ensure that the conditions, as it says, for registration are met. And in this case, the cost judgment does do that. So there's no question that the court is not able to look at the reasons, because the reasons are given. So whether one wants to look at it in terms of reciprocity, or whether looking at this second way of looking at it, in other words, being able to scrutinise proceedings to see the basis on which the judgment was given, those are the two reasons. And so in our case, there's no judgment laundering, in short, because first of all, the English proceedings did not concern a Swedish judgment. They were only concerned with an award. Secondly, the English proceedings failed. And thirdly, the English costs order in no way give effect to the award or depend on the decision of the ECT, the Energy Charter Treaty Tribunal, in any way. On the contrary, the English costs orders are decisions of a recognised court, in other words, the English High Court, with whom there is reciprocity. And then the second point, which is the one I've just mentioned, coming out of the remarks of my Lord Richards, is that the Gibraltar Supreme Court can adequately scrutinise those orders to ensure that the conditions for registration are satisfied. They are not based on any other decision which may forego proper scrutiny. And as I've said, and this was the point that my Lord Legate made to me a moment ago, we accept that the same would have applied to any costs order which might have been made in favour of the statties had they been successful.
Well, the question is whether you look at the cost orders independently or whether you treat them as going along with the purpose of the claim. And you take the view that if the purpose of the underlying claim is to enforce a judgment of a third state rather than to get a judgment on the merits, then the cost orders go along with that purpose.
My Lord, no. We submit that the English cost orders are entirely separate. They're based on different considerations. Their existence in no way depend on what the reasoning of the award.
Well, the Act might have said that, but unfortunately for you, it doesn't.
But my Lord, it comes back to the two reasons that we're going to look at in terms of the appellate issues, which is whether or not the Section 11A has any application at all in the context of this case, for the reasons that I'm going to come to, which is 11A is concerned with the question of which awards are we going to recognise, which qualifying awards, in other words, English awards. And then it comes to the second point, which I've identified, which is the second ground of challenge, which is the question of whether or not the cost judgment are based on the qualifying award. And that's the point I made a moment ago. Now, that's all I wanted to say in terms of the first point. As far as the legal framework is concerned, I think I propose to deal with this quickly, but it's probably important to do it. Just to make sure I've covered all the points. The legal framework is obviously in the Act itself, and you can find the Act in the electronic bundle starting at 1107, the preamble. And we've referred to the decision of Mr. Andrew Henshaw, Queen's Counsel, he then was in State Bank of India, on how to interpret such legislation. And we've made reference to paragraph 64 in our written case, where he talks at paragraph 64 about how considerations of comity would suggest that it would be wrong to take an unduly narrow or technical approach to its interpretation. And that, we say, is the correct principle. We've also made reference to a decision of the Supreme Court of Canada, and we do so as part of it is in terms of our duty to the court, because we've referred to the strategic case, and there was a dissenting judgment of Justice Cote, where she came to a different view, and we thought that it was right that the board should be aware that a different view had taken place in terms of judgment laundering in the context of the 1920 Act. But there is and we've set it out in our submissions, and I won't deal with it in oral argument, where the learned judge does set out a fairly comprehensive description of how this type of legislation should be looked at, taking into account questions of comity and commercial certainty. But the other judges in that case, justices, were not dealing with the point, and therefore her judgment on that is alone. Now, the Act itself is in two parts. Part 1 concerns the statutory interpretation, that's at 1107, and there's a reference there to a court, and that does not include an arbitral tribunal, and that's the Court of Appeals, said as much at paragraph 72. There's a description of what a judgment is. Obviously, at that stage, there's no reference to an arbitration award. And then section 3, 1108, we can see the reference there to section 3.1, which is the provision enabling part 1 to be extended to judgments of certain courts of reciprocating countries, and that's referred to, the jargon is recognised courts. And then 3.2 sets out the requirements by which a judgment of a recognised court must meet in order to be registrable, and it's common ground that the English costs orders satisfy the fundamental requirements of the Act. They are judgments of the recognised court, the English High Court. They are final and conclusive. They require the payment of money, and they were made after the Act was extended to such judgments. And then we come to the disputed section, the section that gives rise to the dispute with section 3.2a, and we've explained in our written submissions how that came to be incorporated in Gibraltar, and the reference there is at paragraph 34 to 35, and it's common ground that the 1993 Act mirrors the UK's Civil Jurisdiction and Judgments Act of 1982. And then sections 3.2a at 1109 sets out certain judgments of a recognised court that do not fall within section 3.2. And the question that arises, which I'll come to in due course, is how does any of that apply to arbitration awards? Talks about a judgment given by that court on an appeal from a court which is not a recognised court. Talks about a judgment or other instrument which is regarded for the purposes of enforcement of a judgment. And then it talks about a judgment given by that court in proceedings founded by a judgment of a court in another country, and having as their object the enforcement of that judgment. So that's the provision that we're going to need to look at. And then the other provisions which are relevant are section 4.2 at 1110, which provides a judgment registered under the Act is to be treated for the purpose of execution as if it were a judgment of the Supreme Court of Gibraltar. Section 6.1a1 at page 1111 is also relevant because it provides for the setting aside of registration, and the respondent has succeeded on this basis in the courts below. And then section 8.1114, which provides in effect that judgments to which the Act applies cannot be enforced by a common law action on the judgment. And as to part 2 of the Act, the only relevant section that we see is section 11a. Again, that was inserted into the Act by the 1993 Act. Our written submission at paragraph 34 explains that. And then we've got the text that we're going to need to look at carefully, which says that the provisions of this Act, except sections 3, 5, and 8, shall apply as they apply to a judgment in relation to an award in proceedings on or an arbitration which has, in pursuance of the law in force in the place where it's made, become enforceable in the same manner as a judgment given by a court in that place. And it's common ground that this should read proceedings on an arbitration, not or. And in this case, that this would be the Swedish seated arbitration. And so 11a enables the enforcement of arbitration awards made in countries to which the Act has been extended in the circumstances defined. It is the same under the 1920 Act and the 1933 Acts, and we've already seen that from the passage in Dyson-Morris at Rule 72, which we looked at a moment ago. And the Court of Appeal held that the Swedish award was an award for the purposes of Section 11A, meaning that the provisions of the Act, with certain exceptions, apply to it as they apply to a judgment, including Section 2AC. And that's the point that we challenge. Now, as far as the third part of my roadmap, the relevant legal principles, I'm going to take that very shortly because there doesn't appear to be really any dispute between the parties. The purpose of looking at that material was to, first of all, to work out what is the purpose of legislation like this, which we've already covered. And then it seems to be common ground between the parties that the purpose of Section 72A C is about judgment laundering. And therefore, in my submission, it's not necessary to go into the legal principles which are set out in the submissions. The Court's familiar with them. I'm happy to go through them if they assist, but in my submission, there's nothing special about those principles, and therefore I was proposing to deal with it very shortly. And it really comes down to 5 points, which is that the text is the primary source of interpretation, and the reference there is the RNA case of Lord Steyn. The respondent appears to suggest that somehow we're ignoring this, but in my submission we're not ignoring the text. The second point is that all legislation must be interpreted in the light of its context, including its purpose and scheme. And we've referred to the Packard case, Lord Sales, paragraph 41. The third point is that the legislature is presumed to have drafted legislation reasonably, and the reference there is Central Evaluation Officer Lord Bingham at paragraph 116. And then the fourth point is that the flip side of this is that the legislature is also presumed not to intend a result which is absurd, which is given a wide meaning and includes what is impossible, unworkable, impractical, inconvenient, anomalous, illogical, futile, pointless, or artificial. And the reference there we give is to the Central Evaluation Officer case at 116, and more recently to Packard, Lord Sales, paragraph 47. And then the final point is, which we of course accept, is that caution should be of course exercised in the face of any decision which might have the appearance of judicial legislation as opposed to interpretation. And that comes out from the speech of Lord Nichols in the ICO Europe. There is a typo in my submissions at paragraph 52 where I referred to Lord Jones rather than Lord Stevens in referring to Benyon. I apologise for that.
Lord Stevens dissented.
Exactly, but it was only the reference to Benyon that we were referring to. But you're right, and I apologise for that. So that leads us then to the issues on the appeal, which is the fourth part of my submissions, and it breaks down into the two issues that we've identified, and it's logical to start first of all with the Section 11A issue first. I make reference to the Court of Appeal decision. Of course, there's only one judgment, Sir Colin Rymer, with whom the other judges, Sir Patrick Elias and Sir Maurice Kay, agreed. And the Court of Appeal upheld the decision of Mr. Justice Yates that Section 11A enables Section 3(2)AC to be read. And perhaps we can just get the text of the judgment. It's paragraph 36, which is in the electronic bundle at page 59, but it's paragraph 36, where this appears to set out the main thrust of the decision, and just find that. Yes, it's paragraph 36, where the conclusion is that for the purposes of Section 2AC, it must be read as meaning a judgment given by the recognised court, the English court, in proceedings founded on a qualifying award of Swedish arbitration and having as their object the enforcement of that award. And so in doing so, of course, what the meaning of a...
Sorry, paragraph 36 of what?
Of the judgment of the Court of Appeal, Sir Colin Rymer. It's at page 134 of the key documents bundle, and page 57 of the 59. 59, sorry, 59, yeah.
Thank you.
And then in terms of what a qualifying award is, you've got to go back one page to paragraph 33 in the middle there, where he refers to section 11A and the passage that I read out a moment ago, and he says, I shall call that a qualifying award. So in doing so, he dismissed the argument made on behalf of the appellant that section 11A could not enable section 32AC to be read as applying to a Swedish arbitration award, because this was not a judgment of a court of another country applying the statutory definitions of judgment in court, and it held that this would reduce section 11A to a dead letter, because it would mean that an arbitration award could never be registrable under section 32, and that's paragraph 32 of the Court of Appeal judgment, going back to the electronic bundle at paragraph 57 and the key at 132. And the focus of our argument is that section 11A is directed exclusively at enabling the registration of arbitration awards of reciprocating countries rather than the prevention of money laundering, of judgment laundering. And that was an argument that we made below. See the Court of Appeal judgment at paragraph 31 at the end there. And I should start by reminding the board of the decision below on this issue. And it seems to us that the Court of Appeal dismissed this argument for a number of reasons. The first
I haven't quite yet understood. I thought, suppose that the English proceedings had succeeded and the English court had made an order that the Swedish arbitration award can be enforced in the same manner as a judgment. Would that have been enforceable in Gibraltar, or would it have been caught by 35, by 2AC?
It may have been called by B, 32.
32AB.
Yeah,
AB.
yes.
Right, okay.
So that's where it would have get caught. That's how that one would have been caught, because there is a judgment, but it's taken out by B. So that's 32AB. So if we go through the reasons, the first reason is at paragraph 35 of the Court of Appeal judgment, which is at 59 of the electronic bundle. Where it said that section 11A, which was introduced into the 1935 Act at the same time as section 32A, is precise as to the provisions in the Act that do not apply to it. Had it intended to also to exclude any part of section 32A from such application, it would have said so, but it did not. So that's one reason I need to deal with. The second reason is at 35, where it says that section 32AC is directed to the important policy objective of avoiding registration which would result in the laundering of inter alia a non-registrable third country judgment. It would be surprising if it were not also intended to prevent the laundering of inter alia non-registrable third country qualifying awards. The third reason is at paragraph 35 again, where it said that Dicey and Morris Rule 3072 provides no support for the appellant's argument because it was exclusively about the registration of arbitration awards made in reciprocating countries, not about section 32AC. And then the last way, the last reason is paragraph 35 again, where it's held instead that the correct court approach was for the court to perform, and I'm reading from the final sentence, the easy task of interpreting the combined effect of section 32AC and 11A. And as to that, it held that all the requirements of the Act were met, and that's at paragraph 36. The English cost orders were judgments of a recognised court. Mr. Justice Yates had held that the award was a qualifying award, and it was not being suggested that this was wrong. And then the third part, the awards was therefore a judgment of a court in another country, which did not have to be a country with which Gibraltar had reciprocal arrangements. And we contend that this approach is wrong with respect for the following three reasons. The first reason is that Section 11A is clearly directed at enabling the registration of arbitration awards made in reciprocating countries. And hence, looking at 11A, the requirement that the award has become enforceable in the same manner as a judgment of the court in that place. And that place is intended to be the country with which Gibraltar has agreed these reciprocal arrangements, not a third country. And just to go back to the dicey passage that we looked at a moment ago, it's at 1931. If we could turn to that, please. Where it says, an arbitration, that text I read, an arbitral award made in a country outside the United Kingdom, in other words, to which the 33 Act applies, is enforceable in the same manner as a judgment given by a court in that country.
What is the status of Gibraltar as regards the New York Convention? Is it a separate party, or is it a party because the UK is a party? This point is covered by my learned friend in his notes. If you look at the website of the New York Convention, there's a reference to all the states that are parties, and there's a reference to United Kingdom, and then there's a footnote referring to Gibraltar as a British overseas territory. And the way the point is dealt with is in my learned friend's note about enforcement, which was para 71 of the key documents, but I'm not quite sure what page it is. But what is said is that the yes, it's paragraph 23, where it's pointed out that the New York Convention is given effect in Gibraltar by Part 4 of the Gibraltar Arbitration Act of 1895 at sections 47 to 53. So is that the equivalent to Section 101(2)
Yes.
of our Arbitration Act?
Yes.
So how could that have worked? So suppose they'd not come to England at all. They've got this Swedish arbitration award. According to Swedish law, it's to be treated as a judgment in Sweden. Is that a necessary step if they had wanted to enforce it in Gibraltar directly under the Gibraltar Arbitration Act? How could that have worked? Or
The way it would have worked is as in England, they would have got their award. They would seek to enforce the award as a New York Convention award in Gibraltar, using the equivalent sections of sections 107, 101 that we looked at a moment ago under the Arbitration Act. The fact that the award had the status of a judgment, a qualifying award in Sweden, is irrelevant to the question of enforcing the New York Convention award in Gibraltar. In the same way, they've got this award. They can go to any of the states that are signatories to the New York Convention, which is exactly what happened here.
But is the legislation in Gibraltar giving effect to the New York Convention?
Yes.
There is.
Yes.
So the question is, why didn't they just adopt that course?
Because yeah, they haven't, and they don't, and they haven't sought to enforce the award in Gibraltar.
But
no doubt,
if they could. They could.
Well, if they did, they'd be met with the same
Of course.
the same fraud case.
Yes, but you may not have any assets in Gibraltar.
Yeah, exactly.
So there's no point them.
No one's ever thought about enforcing this arbitration award against Kazakhstan. I'd be very surprised, but I've obviously got no instructions on this, whether or not there are any assets in Gibraltar.
No.
But this reflects a whole artificial nature of this exercise in terms of award laundering. No one's ever had any interest in Gibraltar. Had they really wanted to enforce an award in Gibraltar, they could have done so under the New York Convention. So there's never judgment or award laundering was never going to be an issue in this case.
You must think that they've got assets in Gibraltar. That's why you want.
They are incorporated there. Yes. And so if you enforce in Gibraltar,
Yep.
What is the basic reason, I still haven't grasped it, why you don't just read judgment of a court in another country by virtue of 11A as including the Swedish award? Why don't you do that?
Because that's not what the section said. I mean,
why doesn't it say that? What is your basic? I mean, it fulfills the requirements of 11A, doesn't it? It's an award in proceedings and so on. And so why doesn't it just get substituted for a judgment of a court in 2AC?
Because what Section 11A is doing is effectively giving another head or type of judgment that's going to be recognised. There was a lacuna, because it had always been there in the 1920 Act, but it wasn't there in the 1933 Act. I don't think it may have been used, but it's quite an. When one's got the New York Convention route to do it, it seems very difficult to think why anyone would ever want to do that sensibly. But in my submission, what is happening here on this first level of the argument is that it's been decided that we're going to extend this treaty to cover qualifying awards, awards of a particular nature. And those are the awards that are referred to in the dicey passage. So we're talking about English awards. This does not apply to the Swedish award, because the Swedish award is not a qualifying award for the purpose of the 1935 Act, or the 1933, the equivalent to the 1933 Act.
But if the purpose is you want to be able to scrutinise for yourself the conditions of enforcement, then that purpose clearly applies here, doesn't it?
My Lord, it's the first limb of argument is your Lordship's going into the second argument. The first limb of argument.
Not entirely, because I'm looking to see what counts as a judgment of a court in another country here.
Yes, and in this case, it would be if the arbitration award in England had effectively been recognised, for example, as a common law, been enforced as a matter of common law. So there would be effectively an award under English law that had the effect of a judgment. That's the thing that's being looked at. And in my respectful submission, that is all that Section 11A is doing. We are now agreeing that not only judgments, but certain awards, as issued by the English court, are going to be capable of registration, and that's what Article 72 of Dicey and Morris is saying, and so that's basically what it's saying, and therefore you never get into the exclusion, because that is what on this first limb of the argument is concerned with. One is asking oneself the question: what types of award are we going to be dealing with? And the only types of award that we're dealing with are awards under English law that have the status of judgments.
But sorry, does that answer?
Well, I don't quite follow why, in that case, this doesn't apply to 3.2a. I mean, because I think it's the point Lord Legate is making, that if on your construction of 3.2a, if you've got an English judgment recognising the award, you're saying, well, that's not excluded, as I understand it.
Well, no, that's
3.2a.
That's not an award. You're not enforcing that. There's a judgment. So your Lordship's example is not the correct one. We're talking about arbitration awards, not judgments. The position under judgments is different.
You're saying, aren't you, as I understand it, that Section 11A does not read into 3.2a?
Correct. Sorry, I'm sorry. All I was saying is that 11A, on the primary, the first limit of this argument, is broadening the category of legal instrument that we're going to enforce from judgments into arbitration awards falling within a certain category. That's all it's doing. So it's an enabling provision. It's not dealing with the exclusion.
But you say that awards under the New York Convention are not within the category that's at which Section 11A is directed, because under the convention it's the award which is hawked around the world trying to enforce it. But why is it pursuant to the convention that Swedish law treats the award as a judgment? Is there, presumably the same happens in every party to the New York Convention. Does that require some step of the Swedish court, or is it Swedish law, because they have to implement the convention, that every New York Convention award within their remit is to be treated as a judgment of the Swedish?
No, the status. So we're postulating an example where an award has been made in Sweden,
yeah,
and it's unsatisfied, and then a party wants to enforce that award under the New York Convention. So it goes to, as my lady said, hooks it around the world to whatever state it wishes. But as far as we are concerned, the only question, and this is the requirements in Section 101 in terms of what needs to be produced in order to get the award, and at no stage of the analysis in terms of getting that award enforced under the Arbitration Act is there any discussion or investigation of the question of what is the status of this award under Swedish law? Has it become effectively recognised as a judgment? That's not a question that ever arises because it's irrelevant.
Well, it might be because it's irrelevant, or it might be because we know that because Sweden signed up to the convention, then the awards, Swedish New York Convention awards, must be, under Swedish legislation, treated as judgments of the Swedish court. Why do you go through this conversion of the New York Convention award into a Swedish judgment if it doesn't make any difference to the enforceability of the award around the world? Why is there that step?
Well, the step, which may make sense as a matter of Swedish law, in order, for example, to enforce it domestically, one can perfectly understand that, and that's what the Swedish enforcement code appears to do.
Right, but you're not saying that that's a requirement of the convention that the states parties do that.
The way the Act and the New York Convention operates, there's a requirement to produce certain things. For example, the agreement to arbitrate. And then there's various other things that are stated that you must produce in order to get your ex parte enforcement of your arbitration award. But there is no requirement, express or implicit or in practice, which goes into the question of whether or not the award in Sweden is either a judgment or is capable of enforcement of a judgment, because that is not a relevant question under the New York Convention.
No, it's a relevant question under the Gibraltar Act. That's what Sir Colin Reimer called a qualifying award. What he meant by that was it satisfies the conditions set out in 11A.
Exactly. And that's
once it's a qualifying award, yes, you can forget about what its status is in Sweden, because that box has been ticked. Is that right? I mean, we needn't be concerned with that here. Everyone agrees it is it is, quote, a qualifying award. And that's, as you say, nothing to do with the convention. It's simply the requirement of Section 11A. Is that right?
No, it's not. It depends what.
Well, it is, well, okay, take it in stages. It is a requirement of Section 11A.
No, it is if you want to enforce it as an award, because what section?
No, I'm talking about this Act.
The Act said.
Under the Act, before we talk about arbitral awards, it has to satisfy the condition in Section 11A.
Yes, and if it satisfies that condition, and it's an English award, it's capable of being registered under the reciprocal arrangements between England and Gibraltar.
Yeah.
And the fact that it may be a qualifying award under Swedish law is irrelevant, because you're not seeking to enforce on that basis, because it's an award that you can't enforce anyway, because it's not caught by the Gibraltar Act.
Okay.
And so
if it's an English award, it would have to satisfy the qualification in 11A.
Exactly, and that's
which is not that it is a judgment, but that it is enforceable as if it were a judgment.
Correct.
That's the condition. Yeah,
that's correct. And it doesn't apply here because the Swedish award doesn't fit within those criteria at all.
So, can I ask you this? If you've got an order of the English court under Section 101 of the Arbitration Act, recognising or registering, whatever it is, a Swedish award. Okay.
Yes.
Is that order a judgment of a recognised court within the meaning of Section 3.2 of the Gibraltar Act?
No. No. Let me just get the. I mean, the reason it isn't is the reason that I mentioned in my submissions. It's not a judgment. It's not enforceable anyway, because it would have to be a judgment for the payment of money. And the example that your lordship's just given me is not a judgment for the payment of money.
I mean, this is key, isn't it? Because, I mean, I can see that if it's not within 3.2, one needn't be bothered about excluding it under 3.2a. But if it is within 3.2, then it will be very odd if it's not excluded under 3.2a.
Well, it's not within 3.2.
Well, is that not the key question?
Well, it is important but not critical, because the judgment that we are seeking to enforce is the cost judgment.
Yeah, but that's your second point.
Yes.
The first question is whether if they got a judgment, how that would work.
Yes. Yeah. So just sort of tying up this first line of argument is that the point that, I mean, just to go back to the Court of Appeal judgment to pick this up, which is paragraph 34, page 58 of the electronic, and page 133 of the core bundle. Where it speaks, it is clear that Section 11A enables a qualifying award made in a reciprocating country to be registrable under Section 3. Now that, of course, doesn't apply to our case, because the award wasn't made in a reciprocating country. A reciprocating country here, whether we want to call it a reciprocating country or a recognised court, is England. So that's the point there, which is why we say the Swedish award cannot come within the scope of the Act, because Sweden is not a reciprocating country. It is not a signatory to any treaty between England and Sweden, and between us and Gibraltar. And therefore, when we come therefore to look at Section 3.2ac, a judgment of a court in another country, that can't include a qualifying arbitration award, because that is taking the effect of Section 11A beyond what was intended. So that comes back to my point about what Section 11A is doing. And looking at the wording of Section 11A is when it talks of shall apply as they apply to a judgment, is a reference to a judgment of the reciprocating country, which is missing here. And as to the tribunal's finding that Section 11A is precise, and this was the first reason I identified, as to the only provisions in the Act that do not apply to it, there's a reference to Section 3, 5 and 8. 3, 5 doesn't apply here. It's to do with the definition of the superior courts. But Section 8 is important. And it's clear in my submission why Section 8 is excluded. It ensures that you can still enforce an award that is capable of being registered in other ways, including under the New York Convention, if that applies. And that's the point that is made in Dicey and Morris. If we could turn to that in the electronic bundle at page 1934, where there's a note at section 16154, where it says this: where an award is enforceable by registration under the 1933 Act, it will remain enforceable at common law or under Section 66 of the Arbitration Act, 1996. This is because Section 10A, which is the equivalent of our provision of the 33 Act, provides that Section 6 of the, and that's Section 8 in our case, which makes registration the exclusive method of enforcement, is not to apply to enforcement of awards under the 1933 Act. So it leaves open the possibility. So there is a rationale.
Give me that page reference again.
My Lord, it's at it's Dyson Morris, paragraph 16-154,
Yeah.
and that's in the electronic bundle at 1934.
So it's disapplying the provision that makes this the exclusive
Exactly.
route for
Exactly.
enforcement.
So if there are other ways that you can get your remedy or enforce your judgment, your award, you are able to do so. So we also, the next point, in my submission, it is a separate point, but on the same first issue, is that we say that Section 3.2a is squarely concerned with judgments of courts. Neither A nor C makes sense as referring to an arbitration award. So if we can look at 3.2a again, and look at subparagraph A, and that's because it makes no sense to refer to an arbitration award which has been made on appeal from a court which is not a recognised court. And as to C, this is because it makes no sense to refer to an arbitration award made in proceedings founded on a judgment of a court in another country. And that indicates, we submit, that Section 11A was not intended to have any effect on the meaning of Section 3.2a, let alone having the effect that the Court of Appeal has found it has. And then the last point on this point, the first issue, is the point that we contend that it's absurd to conclude that Section 3.2ac prevents the laundering of qualifying award. Because that involves suggesting that there's a difference between the laundering of qualifying awards and non-qualifying awards. We say that that can't be intended. And furthermore, from the perspective of Gibraltar, as a party to the New York Convention, it makes no sense to talk about the laundering of New York Convention awards, since any party seeking to enforce a New York Convention award in Gibraltar could simply take it to the Gibraltar Supreme Court and seek to enforce it directly, which is a point I raised with my Lady Rose a moment ago.
Sorry, I haven't understood this last point. Why isn't it there a point in preventing you doing indirectly what you could and should do directly?
Because it makes no sense in the context of awards under the New York Convention, where you just go straight to the court.
Yeah, but you have certain abilities to resist enforcement of the convention award, and those you ought to have in Gibraltar.
But then why is there a prohibition on laundering of qualifying awards rather than non-qualifying awards? So why?
That if it wasn't an award that could be enforced as a judgment in Sweden, then it wouldn't come within C.
Correct. Exactly.
And that wouldn't make sense. So that's your point, is it?
That's my point, madam.
Well, is your point that no Swedish award comes within C?
Yes.
That doesn't really matter what its quality in Sweden.
Yeah,
It's because it's not.
It's not within
not a
it.
It's not a recognised country, is it?
Exactly. Exactly. And you don't...
So when you read the reference to judgment as a reference to an award, that you say means an award from a reciprocal country?
Yes.
A recognised country?
Yeah, a recognised country, yes, England, and therefore doesn't apply in our case. Well, that's all I wanted to say on the first of the issues. The second one is the...
Can I just go back
to
the question I did ask you and you briefly...
Did I not answer it?
Under section 3.2.
Yes.
So just spell out for me, if you wouldn't mind, why a judgment of a recognised court. So I suppose perhaps it's better to look at it at 4.1. In a sense, it's the same point. Why a judgment to which this part applies does not include an order under Section 101 of the Arbitration Act made by the English court.
Yes, I think that may be the point I'm about to come to.
Oh, is it?
So,
right.
so if we can,
I'll hold fire.
I'll see if I answer your lordship's question. I'll do my best. Now, what the Court of Appeal held is that cost orders fell within Section 2AC and were therefore not registrable under the Act. And again, let's just, if we may, let's go through the reasons as to why that conclusion was reached. The first reason is that there was no doubt as to what the relevant words meant, and this is the passage in the Court of Appeal judgment at paragraph 46, in the electronic bundle at page 65, and the key bundle at page 140, where it said that all that is required is to ask whether the judgments given by the court, i.e. the recognised court, in proceedings founded on a qualifying Swedish award and having as their object the enforcement of that award. And it said the answer to that question is yes. So in effect it found that the text was satisfied because we have here a judgment given by an English court in proceedings founded on a qualifying Swedish award and having the object of enforcement of that award. Then it's the second point we submit is this: it held that that there was no scope for attaching a purpose of interpretation because there was no ambiguity, and that's at paragraph 47 of the Court of Appeal decision, electronic reference 65. And then the third reason to say there's nothing before us to suggest that the language is a result of a drafting mistake, and that's at paragraph 47. And if you're the board can just look at what is said there. So those are the essence of the decision on section 3.2ac. And we say that that is wrong for these reasons. Looking at section 3.2ac, it requires that the judgment in question to have been founded on a judgment of a court in another country and having as their object the enforcement of that judgment. And what the Court of Appeal held, as we've just seen, is that that is to be read as founded on a qualifying Swedish award and having as their object the enforcement of that award. And that's paragraph 46. And now, as I've already submitted, my argument proceeds on this basis. The first question is to characterise the juridical basis of the English proceedings. They were brought under section 101 of the 1996 Act with the object of enforcing the award as a New York Convention award. The next point, the issue applying the language of section 3ac is whether those proceedings were founded on a qualifying Swedish award and whether they had as their object the enforcement of that qualifying Swedish award. We say that the English proceedings were not such proceedings because they were not proceedings to enforce the award as a qualifying award, i.e. on the basis that it had the same status under Swedish law as a Swedish judgment.
This is your first point, isn't it? recycled.
It may be.
I mean, if you're wrong on that point, then that's when we consider the second argument.
It's entirely separate.
Right.
The first argument is based on the argument that when one is looking at what Section 11A is about, it's about looking at qualifying awards. In other words, English awards.
Yes.
So that's about an English award. This has got nothing to do with this point.
So now we're supposing that you're wrong about that.
Yes. If I've won, then I can go home.
Of course, exactly.
I'm away.
Yeah. So we are assuming now that when it says judgment of a court in another country in 2AC, it includes this award, this arbitration award.
Yes, but my submission still remains that you've still got to have proceedings founded on a qualifying award. And my case is
judgment. Well, when you talk about a qualifying award, it's qualifying because it's a judgment of the other country. So I'm getting a bit confused because
the wording is enforceable as a judgment rather than is a judgment.
Right.
So,
yes.
Yeah.
So
if you're wrong on the first point, these are proceedings founded on
correct. That's
a qualifying award.
Exactly. And the answer to that is no, because they aren't founded on a qualifying award, because we're not seeking to.
Well, you are seeking to enforce the award as a judgment.
No, I think that the point is that when one's talking about proceedings founded on a qualifying award, the question is, were the English proceedings founded on a qualifying award? And in my submission, they were not founded on a qualifying award. They were founded on the basis that this was a New York Convention award, which has got nothing to do whether or not they have the status as to whether they were a qualifying award under Swedish law. That's my submission.
You say if you're wrong on the first point, and it did in fact fall within 11A because of the way 11A is drafted, nonetheless, when you're looking at what the cost orders are founded on, they're not founded on the award because it's a qualifying award. That's just a happenstance. They're founded on the actual New York Convention award.
That's correct, and you can see that by reference to seeing what needed to be established in order to enforce under the New York Convention. And as I submitted already, that exercise does not involve any consideration as to whether they were a qualifying award under Swedish law.
Of its status under Swedish law.
Is it
an
relevant?
award surely can be both New York Convention enforceable and a qualifying award, as defined by Section 11A. But if it does comply with Section 11A, then it's a qualifying award.
Well, no, but then the proceedings aren't founded on that.
They're founded on an award, which is a qualifying award under Section 11A. It doesn't mean that the terms of Section 11A have to be satisfied in the intermediate country, England in this case. I mean, clearly not, because this is a Gibraltar point. But if it does happen to satisfy those conditions, why doesn't it?
Because that consideration is irrelevant. Because it's not a question that arises under the New York Convention.
It's irrelevant in England, but it doesn't mean it's irrelevant in Gibraltar.
Well, it's.
But I thought your point was that then it would just be, you would get a kind of patchwork of New York Convention awards which are or are not enforceable in Gibraltar, depending on whether the arbitral seats law treated it as enforceable as a judgment under its law, which it may or may not. I think we've ascertained that it doesn't have to just because it's a party to the New York Convention. Is that the point?
No, but it's enforceable. If the question that my lady is asking, is this award, Swedish award, enforceable in Gibraltar? It is enforceable in Gibraltar as a New York Convention award. The fact that it's also a qualifying award as a matter of Swedish law is irrelevant to the question of of whether it will be
Well,
enforced or recognised.
let's suppose we had a New York Convention award that had been made in Norway, and suppose Norwegian law didn't have anything in it which said New York Convention awards are enforceable in Norway as if they were judgments of the Norwegian court. Now, as I understand it, Norway would not be in breach of its convention obligations by not including anything like that, but you would say, well, then that would not be a qualifying award under 11A, because there's nothing in Norwegian law that makes it a qualifying award. And if that's right, and it therefore was not within 32AC, then there's no real distinction between that award and a Swedish award. In both cases, what the proceedings would be in England would be founded on the arbitral award, the Norwegian award, not on some judgment which, or enforceable like a judgment, because it wouldn't be a qualifying award. I haven't expressed that terribly clearly.
No, my lady's right. I mean, the point I'm making on this second argument is that you need, looking at section 3.2ac, assuming I've lost on the first argument, and therefore the section is in play, the question that needs to be asked by the court, the board or the court asking this question, is whether or not the judgment in question is in proceedings founded on a judgment of a court in another country. Now, the proceedings that we're talking about are the English Commercial Court proceedings, and we submit that they are not founded on the basis that there is a qualifying award, as your ladyship.
You're saying, is this right, that we should interpret 2AC not as meaning that it's sufficient that the proceedings are founded on an award, and it happens that that award is a qualifying award, but it has to be founded on the characteristic of the award being that makes it qualifying?
Correct. That's my submission. And you can't just, we'll come to look at this in a moment, you can't miss out the words. As I think my learned friend in his submission at one stage, where he simply says, is this a judgment given by that court in proceedings having as their object the enforcement of that judgment or qualifying award? It's not enough just to, of that award. It's not enough that there's talking just about enforcement. It's about enforcement in the context of where you are relying on a qualifying award. And in the context of the New York Convention with which we're concerned, we are not concerned with that. We're only concerned with enforcement of an award. It's wholly irrelevant that it happens to be a qualifying award, as shown by what happened in this case.
It's irrelevant in England. It's not wholly irrelevant in Gibraltar when you come to enforce.
It's
Well, that's the question. Right?
yes.
That is the question.
Yeah.
Yes, but
I mean, what as I say, that is the question, and we say that it's when one's talking about following judgments of a recognised court, in other words, the cost judgment. So just working through the language, so the following judgments of a recognised court are not within it. So we're within it. Are we taken out because the cost judgment was given by that court in proceedings, English Commercial Court proceedings, founded on a judgment of, and assuming I've lost on the first point, a qualifying, the qualifying award point. And as I say, we say that the answer to that is clearly no. And that's reflected in the fact that there was no requirement to allege or adduce in the English proceedings that the award has, under the law in force in the place it was made, become enforceable in the same manner as a judgment. And it's evident from the facts of this case where the status of the award is, and it emerged for the first time during oral argument. So it was never relevant until it came up in that context. And as I've said a moment ago, if one turns to my learned friend's submissions at paragraph 58, which is at 1058, where he says, if we can just turn to that, please.
Sorry, paragraph.
It's paragraph 58, and it's in the key documents at 63, or the electronic at 1085. So when my learned friend says at 63, I think it is, let me just check. At the top of the page there, where it says is that section 1012 is plainly an enforcement provision. It provides, and it sets out the text. And then it says this: it follows that on any view, the English proceedings were proceedings, ... having as their object the enforcement of the award. With respect, that's not what the test is. It's not just, is it about enforcement of the award? It's about the enforcement of a qualifying award. And the board has my submissions that is the important.
So you rely on this point to limit both the meaning of founded on and the object of the enforcement. Basically.
Correct.
You say
that's right, my lady.
It's founded on the award here, the Swedish award, which just so happens, but who cares, to be a qualifying award. And similarly, it has as its object the enforcement of that Swedish award, which just happens, but who cares, to be a qualifying award.
That's correct. That's my submission. So we say, and this is the next point, is that we say that section 3.2a C is concerned with a specific kind of enforcement, which if successful leads to a judgment on a judgment, and that's its acknowledged purpose. And what we say is that, read in its context, it's clear that what's intended to be caught here is a judgment on a judgment obtained by, for example, a common law action on a foreign judgment or a similar process. So when we
say a similar process, what do you mean?
A foreign judgment by statute.
By statute,
yeah.
Yes.
And so we say that proceedings founded on a judgment of a court in another country, that's a reference to a common law action on a foreign judgment or something similar. And we've referred to the Lord Chancellor's Department notes where that point is made in terms of what's behind this. In other words, it's similar to common law action in the United States, in the United Kingdom. And what we say here is that's what this is really intended to catch, which is obviously not the case in the present case. We haven't got that.
You'll have to, so, are you just focusing on paragraph C, or are you including B as well here?
C versus B. B would cover a judgment.
B would
cover a judgment which had been registered.
A registered?
Yeah, yes, but which we haven't got here.
You're saying that C is all about proceedings that you bring substantively to enforce a judgment under common law or under a like system.
That's correct. That's my submission.
But B, why do you say B wouldn't cover a registered award?
It would.
Right. It would.
It would if and it become a judgment, because there is a judgment then.
But if it's a question of registration, does it become a? I mean, if an award is registered under the 1996 Act, it doesn't become a judgment of the English court, does it?
No.
It's registered.
It can be made. It can be. It's registered.
Regarded for the purposes of its enforcement
as a judgment.
That's your point.
Yes.
But I thought you said a minute ago that it wouldn't be caught by 3.2 because it wouldn't be a judgment for a sum of money.
If that's all it is, but under the Act, this didn't happen in this case. There's an ability to enter judgment in the terms of the award. In other words, going one stage further. So there's two types of, and that's why I refer back to the judgment, to the order of Mr. Justice Burton, which made it clear that there wasn't in fact a judgment. There's never been a judgment either in Sweden. There's never been a judgment on this award in England either. So my Lord Legate's correct. That's the way we put the case in terms of what it's being, what's called. It's common law or under statute. And we say, therefore, that we're concerned with judgments on judgments, and that is consistent with its legislative purpose. And that, I suppose, leads on to my last point.
So you mean it's concerned with judgments on judgment, not judgments on awards?
Correct. And certainly not judgments on awards which are qualifying awards.
I'm sorry, but why do you not, just repeat for me, why do you not read 2AB, let's focus on B for a moment, with section 11A and say that a qualifying award is a judgment or other instrument?
Let me just... So a judgment or other instrument which is regarded for the purpose of enforcement of a judgment of that court which was given or made in another country.
I think you're accepting if the proceedings had succeeded, then
Yes.
it would have been.
Yes. Have they? Yes. Yes.
Right. Thank you.
Sorry. Yes, I had said that earlier, but I should have repeated myself.
All right. Thank you very much. Right.
Now, the only other point to make is...
Sorry, in B, so the judgment of that court is the English court?
Yes.
Yeah.
Yes.
So if the proceedings in England had been successful and they'd got the order they were seeking, then that order would have come within 3(2)AB.
Correct.
And it would not, therefore, be enforceable in Gibraltar.
Correct. Now, the only other point I was going to make was in terms of the what I might call the absurdity point.
But just pushing that one, but if they'd also got a costs order against you, would that have been enforceable
Yes.
or not?
We accept that. The logic of our argument is that the cost order would be enforceable. There's no basis for effectively. I think what was submitted below, we are not following. Right. We accept that the logic of our argument must apply to any costs order, because it's not a judgment on a judgment. It's freestanding. There's no prospect of money laundering, of judgment laundering or award laundering, and that is a concession, or not a concession, that we accept that that's the case. And so we're left, therefore, with the sort of what we describe in our submissions as the absurdity point, which we develop in our argument at 78 to 81, which is that we say that the result of the case, which is that the cost orders are not to be registered, undermines the purpose of the Act, which is to undermines the purpose of the Act by preventing the enforcement of judgments which involve no judgment laundering and which would otherwise be registrable. It also captures cost orders reflecting failure or success in enforcing the judgment. And we say that the outcome is contrary to comity, convenience and commercial certainty. Our case is that the English court's judgments are freestanding. They were made in proceedings which were discontinued, and there's no reason as to why they should be denied recognition on the basis that they involve judgment or award laundering, where the whole basis of the cost thing has been to resist that. It's the opposite of judgment laundering or award laundering. We're saying that this award is unenforceable for reasons of public policy. So you can be satisfied that if the appeal is allowed, there is no prospect that anything that has happened here can amount to judgment laundering or award laundering. My Lord and my Lady, that's all I wanted to say. I think I'm within time, and unless I can assist you further, those are our submissions.
You're well within time, Mr. Malik. Thank you very much.
I did invite you to address us on section 4.1, and I think you said you'd come back to that. I think this goes back to your first main argument rather than the argument you've just been addressing. So what I'd just like to understand is where section 4.1, which is perhaps the nub of the Act, really, a person being a judgment creditor under a judgment to which this Act applies, you say that judgment there cannot include a recognition order under the Arbitration Act.
That's correct.
Now, why? That's what I want to know.
Because for the first reason is that the scope of Section 11A is only to cover certain arbitration awards, and we're not within that. Obviously, if it is an award which is caught within the Act, then for judgment, one's got to read award. And so the answer to my Lord's question may be yes, if it is an award within the Act and is an English award and not a Swedish award.
Can I follow that?
And of course, the other point is that there's got to be a judgment which is involving the payment of money, simply, which is the point I made at the outset of my submissions.
So you mean the order made under the Arbitration Act does not involve the payment of money?
Depending on what its form is. If it's just simply we're going to capable of enforcement, yes.
Justice Burton's order, was it?
Yes. That's all it did. It didn't involve a judgment.
Is that always going to be the case, or why was the order made by Mr. Justice Burton in that form?
It may be because it was only at that stage ex parte. It may be that at that stage that was all that was being sought. I can't recall what was said, and I haven't gone back to the papers. All I can do is point your ladyship to the order in terms of what it was said. And what it didn't do was it didn't actually go as far as making a judgment. It doesn't say that.
But is the form of it determined by the Arbitration Act or rules under the Arbitration Act?
Yes, that's right, it is. But I mean, you can make an application under both heads to enforce it as a judgment, and you can ask for permission to enter as a judgment, and that's under the Arbitration Act.
Yes, it's 101, 2 and 3. So
Correct.
What did, just remind me what Mr. Justice Burton...
He did 2, not 3.
So it was an order, so it's an order of the English court giving leave to enforce the award in the same manner as a judgment of the English court.
Correct.
But might then, on your argument, might the form that the order takes that's made by the court under Section 101 actually be very important in determining whether it's going to be enforceable in Gibraltar?
Well, whether it's going to be enforceable under Gibraltar depends on whether or not it falls within the Act. We say that it doesn't fall within the Act for the reason, the two reasons.
I think what my lady's asking is whether it falls within the Act depends on which particular version of the order is made, or whether you say it does on this point.
It makes no difference on my submission.
But I mean, it is an order. I just want to...
Why? Because one's a money judgment, but the other isn't.
Exactly.
It does make a difference.
Well, if it's a money judgment, then it's capable of coming within the convention, the passage that we looked at in Dicey and Morris. If it's just as in this case, outside the Act, the registration, because it is a Swedish award rather than a non-Swedish award, and if, as we contended, this is an award in proceedings based on a qualified award which is under Swedish law, but not within the Act under English law, and that's a distinction that we make, and that's why I keep coming back to my 2 points.
I know you've got various points, but one of your points is that it makes a difference. To be a judgment, it has to be a money judgment.
Correct.
And for that, on that point, it does make a difference, doesn't it?
Yes.
Which version of the Mr. Justice Burton make, or any judge in the proceedings, which version of the order he makes. Otherwise, you wouldn't be mentioning that at all. I mean, it is on one argument that you make, that is a relevant difference.
On one argument, yes.
So to understand, so I can understand the point. Mr. Justice Burton's order, it does not, is this right? It doesn't, you submit, satisfy the condition in section 3(2) little b. Is that the point you're making?
Well,
because it's got it to be the judgment of the record.
It doesn't come within the definition of a judgment in the Act, is that right?
That's correct, and also the
therefore it doesn't come within.
Why is it not within the definition of a judgment in 2(1)?
Because the 2(1) judgment that we're talking about, a judgment of a recognised court.
I'm
That's
looking
a
at the
reference.
definition of judgment in section 2(1). You've just
You
say it doesn't come within that.
Yeah, I say that.
Sorry, let's get it in stages.
Sorry.
Do you accept that the order made by Mr. Justice Burton is a judgment within the meaning of section 2(1)? Just pausing there.
It's difficult to answer that.
I mean, that's the first question. If it doesn't fall within that, then that's the end.
Well, no,
So
but 2AB doesn't have any relevance in this.
I'm looking at the definition of judgment in section 2(1). Is Mr. Justice Burton's order a judgment within that meaning or not?
No, because that is we're talking about the recognition of judgments as between England and Gibraltar.
No, I'm sorry. That all comes later.
Yeah.
This is a very simple question. We're just looking at the terms of the definition. All the qualifications about whether it's England and so on come in later. Just focusing on those words in 2(1). I mean,
it is a judgment.
It is a judgment.
The money bit is criminal proceedings.
Yes,
exactly.
Yeah, it is.
So that whole thing is a red herring.
Yeah, exactly.
well, I thought you might be relying, so far as payment of money is concerned, on the conditions set out
We are.
in section 3(2)b.
We are. Yes.
Just to be, it's quite important for us to understand exactly.
I'm sorry.
how you
Yes,
put
we
your
are.
case, Mr. Malik.
Yes.
So you're saying that there is not under Mr. Justice Burton's order a sum of money payable,
Correct.
even though it says you can enforce the award as if it were a judgment.
That's correct, because it doesn't. There's no
order
requirement.
for payment.
No order for payment. We are saying that.
Right. Okay. I follow. Right. And so it follows, and that's why you say.
All right.
That's why you say, do you, that it's not a judgment to which this part applies under section 4(1).
Correct.
I've got this right, have I?
You have.
Much obliged.
Thank you.
Is that a new point? It's always been there, is it?
I wouldn't say it's a new point. I mean,
It just hasn't been discussed before.
I mean, the common law point is one that's been raised before, and there's a reference to the transcript where it came up. My learned friend says, I don't think he takes a technical objection, but he says the point about common law, what it's directed to, common law judgments, is a point raised in the transcript below, and so it's not new in that sense. The problem is that one looking at these sections, they are somewhat complicated, and you see them in different ways, but in my submission, it's not a new point.
I mean, what order, as Justice Burton happened to make, in a way, is neither here nor there. We're sort of testing
Yes.
what happens at the end of the proceedings, and it could have resulted in either order, either kind of order.
Yes.
And your case, I think, is that one would come within Section 3.2 and the other wouldn't.
Yes.
But if it doesn't come within Section 3.2, then there's no question of it being enforced in Gibraltar.
Correct.
Unless you go under the Arbitration Act route.
Correct.
Right. But I'm just worried that courts at the end of these proceedings are choosing which order to make without necessarily realising the repercussions of that. This wording may be reproduced in all sorts of legislation in different countries. Yes, all right.
Thank you, Mr. Malley. Grateful. Mr. Ramsden.
My lords, my lady, I will also endeavour to come in at least on time, if not before. Let me, as with Mr. Malik, just set out briefly my roadmap. And in light of the submissions this morning and the board's interventions, I'm going to be very brief indeed on the principles. I'm going to take you next to the legislation, not least because of the point that's just been raised, which, whether a new point or not, I think is a misconception as to what this case is fundamentally all about in terms of what is sought to be enforced. And then I will come to the two grounds of appeal. Let me just observe briefly, I'll come back to it, what I meant by that observation a second ago. What is not sought to be enforced in Gibraltar is the order of Mr. Justice Burton. It's the costs orders. And it's our case that the costs orders come within Section 3.2b. And once you're in 3.2b, then you are at play with the exception. So whether a new point or not, or an adaptation, we say it's a non-point because the Burton order, Mr. Justice Burton's order, is not at large as a matter of enforcement.
But I think the point is that when you're interpreting, it's relevant when you're interpreting the provision that we're directly concerned with, that had the proceedings gone their course and resulted at the end of the day in a Burton-type order,
Yes.
that judgment would not have come within, according to Mr. Malik, 3.2 at all, and so you never would have got to 3.2a.
Well, I'll make good in due course that the fact that the costs orders, which are money orders, fall, we say, within 3.2. So the exception argument is engaged.
Yes, so the costs orders anyway come within 3.2.
They come within 3.2.
Yes.
And one is then left, essentially, with Mr. Malik's argument that in some way disembodies the costs orders from the underlying proceedings. As he said, those are a separate, albeit under statute, discretionary remedy, which are not to be treated in the same way as a judgment. And I'll deal with that in due course. But that if I can just right the ship, as it were, to that extent, that, we say, is where the proper analysis should be focused. Let me deal very briefly with principle, because I think we perhaps over-anticipated a dispute with the ROC in relation to what the principles were from their written case. In fact, I have no argument at all with the very brief 5-point summary that Mr. Malik provided to you early this morning. And there are two brief caveats to that outbreak of agreement. The first is that although the ROC flirt in their written case at paragraph 86 with the notion that INCO as an alternative argument might apply, namely, we are concerned here in construing this legislation with a potential drafting error, that does not now appear to be the ROC's case. So if we are in any area of interpretative analysis, it is under Shahid, and we are therefore looking at potential absurdity. We accept that in relation to absurdity, cases such as Edison, First Power and the CVO, and the Queen against McCool do attach a much broader definition to the word absurdity, such that, as Mr. Malik, I think, fairly summarised, concepts such as unreasonable outcome, unconscionable outcome, unforeseen consequences would apply. And whether that's a lower threshold or not doesn't matter. We understand the concept. The other caveat, to which I will return in the context of ground 2, is strategic technologies, where, as our written case makes clear, we say that authority is of really no assistance to you because it is concerned with the 1920 Act, which crucially does not contain the exception that appears in either the 1933 UK legislation or the 1935 Gibraltar legislation. But I will make that good in due course.
Well, it has some observations on purpose, which are probably pertinent, aren't they, to the purpose of this provision?
Yes. Yes, and indeed.
As far as that, it has some relevance, or if one can adopt. I don't think there's much dispute about what the underlying purpose of the provision is, but
no,
it's quite well explained in strategic technologies.
It is, and my lord, I think the way we would put that is that although we say it's a very different case, if one takes the analysis of Lord Justice Mayles in adopting the purposive construction he did, his justification for doing that is an eloquent justification for the provisions we're looking at and how they should work. As simple as that.
I didn't really understand, Mr. Malik, to take strategic technologies any further from that.
Well, in which case, I probably won't return to it in the context of ground 2. Let me say this about the legislation. There is a danger, and with great respect to the ROC submissions, it's a danger in part illustrated by their submissions this morning, of attempting, when confronted, we say, with legislation that has a plain and clear meaning, attempting to apply to it a different meaning and finding oneself in a series of different analytical straitjackets, as we say the ROC do as part of their analysis. What I would like to do is to take the legislation carefully in turn and explain what we say its structure is, and then move to the specific submissions on the grounds of appeal. Now, the board has a full exposition of the legislative framework in our written case, and that's Electronic Bundle 1072 to 1077. Given the breadth of that material, I'm going to make these points in oral submission only by way of emphasis. But the first point we make by way of emphasis, which is in paragraph 13 of our written case, that's Electronic Bundle 1073, is that the 1935 Gibraltar Act governs all registrations of foreign judgments, and we say arbitral awards, from reciprocating countries that are not covered by the Civil Jurisdiction and Judgments Act 1993 or Brussels I recast. That is to say, all non-EU recognition and enforcement, leaving aside the common law method of enforcement in respect of other countries. And that, as I say, is set out more fully, paragraphs 21 to 26 of our written case, Electronic Bundle 1093.
Just sorry, if you give me the paragraph numbers of your
Yes.
case when you're referring to them.
So in two parts, summary in paragraph 13 and then paragraphs 21 to 26. The second point we make by way of emphasis is that by contrast in England, the role performed by the Gibraltar Act is performed by the combination of the 1920 Act and the 1933 Act. Now, while similar, those two regimes are not in fact identical. The board has what is hopefully a useful comparison of the 1920 Act and 1933 Act in tabular form at paragraph 16 of our cross-border note, to which Mr. Mallet referred earlier. So that, again, for your reference, is electronic page 1096. And I highlight just 2 points from that note. The 1920 Act does not contain the same clear exceptions to registration found in section 1(2)(a) of the 1933 Act or section 3(2)(a) of the Gibraltar Act. And again, that probably disposes of the point in relation to strategic technologies. The other differences include the mandatory nature of compliance with the 1933 Act regime in place of the common law system. That is to say, if you have a judgment from a 1933 Act country, and in the case of Gibraltar, a 1935 Act country, you can't use the common law system. And that follows from the express words in Section 8 of the Gibraltar Act and Section 6 of the 1933 Act. And we can find Section 8 of the Gibraltar Act, that's electronic bundle, page 1114. No proceedings for the recovery of a sum payable under a judgment given by a court of another country, being a judgment to which this part applies, other than proceedings by way of registration of the judgment, shall be entertained by any court in Gibraltar. Now, by contrast, the 1920 Act allows parties to choose between the common law and the 1920 Act regime, subject only to a cost penalty if they choose not to follow the 1920 Act regime. And that we will see. I don't think we need to turn this up in section 9(5) of the 1920 Act. Going back to the point my Lord Richards made a moment ago, that was one of the differences stressed by Lord Justice Mells in Strategic Technologies. And for your reference, although I don't propose to go to them now, other differences are set out in the table in our written case at paragraph 15. The third point of emphasis is that the basic or threshold requirements for registration under the Gibraltar Act and also under the 1933 Act are found in section 3(2), as we have just been canvassing. We say that section 3(2) is the essential starting point. The requirements in section 3(2)(a) and b essentially replicate the basic requirements found at common law. In other words, in A, that the decision is final and conclusive, as between the judgment debtor, judgment creditor, or requires the former to make an interim payment of the latter, and in B, there is payable under it, the decision, a sum of money, not being a sum in respect of taxes or other charges, so the prohibition on punitive or tax payments. We say that that is really the extent of the parallel between the common law and the statutory regime introduced by the Gibraltar Act. And that is important context, we say, when in due course I will come to the submission that is emphasised far more in the Rock's written case than was the case in oral submissions, that in order to explain the exception in section 3(2)(a)(c), the Rock seeks to do so, indeed we say it is really compelled to do so, by limiting section 3(2)(a)(c) to common law modes of enforcement and not statutory. That's how we'd understood their written case, although there was some fleeting or flirting departure from that in the course of oral submissions. But that's certainly, as we understand their case, that is, Section 328C is focused on common law enforcement. We say that isn't the case. It might include common law, but it certainly doesn't exclude statute. Lastly, by way of emphasis, in terms of legislative history, the board will by now be well aware that, of course, sections 32A and 11A, the amending sections of the Gibraltar Act, were introduced at the same time by the CJJA of 1993. And again, in the context of submissions to which I will come, we say that is an important point, because it is, we say, highly unlikely, if not frankly inconceivable, the drafter did not have the combined effect of those two sections in mind, nor indeed did the drafter intend those two sections as amended to work together. So let me dive straight into the substantive submissions on the grounds of appeal. And as with Mr. Malik and as with Sir Colin Reimer in the Court of Appeal of Gibraltar, I will start with ground 3 and therefore address section 11A. Now, building on our written case, we wish to make essentially 6 short points by way of emphasis. The first is that we say the opening words of section 11 clearly state, and again, I apologise for reference in the electronic bundle, this is 1116. The provisions of this Act, except sections 3, subsection 5 and section 8, shall apply as they apply to a judgment in relation to an award in proceedings on an arbitration which has, in pursuance of the law enforced in the place where it has been made, become enforceable in the same manner as a judgment given by a court in that place. We say that except, the effect of that is to say, except as to sections 3.5 and 8 of the Gibraltar Act. Section 11A has, and we say plainly is intended to have, broad application throughout the Gibraltar Act. And that necessarily includes, we submit, the term judgment in section 3.2AC. Mr. Justice Yates adopted this analysis in his second judgment, the inter partes judgment, at paragraph 37, as did Sir Colin Reimer at paragraph 35 of the Court of Appeal judgment. Now, for completeness, section 3.5 provides as follows, and that is at electronic page bundle page 1109. Any order made under this section before its amendment by the Civil Jurisdiction and Judgments Act 1993, which deems any court of a foreign country to be a superior court of that country for the purposes of this part, without prejudice to subsection 4, have effect from the time of that amendment as if it provided for that court to be a recognised court of that country for those purposes, and for any final and conclusive judgment of that court, if within subsection 2, to be a judgment to which this part applies. So what is the effect of section 3.5? And we say, unlike the ROC, it is essential to walk through this legislation to understand the overall scheme of it. We say section 3, subsection 5, is effectively a transitional provision which excludes arbitration awards prior to the statutory amendments, so that there is no retrospective effect in those amendments. Now, in contrast, it does create retrospective effect for judgments. Now, we say that is entirely explicable on the basis that the arbitration equivalence provision is new, and there was therefore no intention to create a regime for recognition of arbitration awards retrospectively, because no such equivalence previously existed. Now, as for section 8, which is the other exclusion from Section 11, we say that that is equally explicable on the grounds that Section 11A was not extended to Section 8 to avoid any interference with other statutory regimes in relation to the enforcement of arbitration awards. And we say that would primarily in this case have been the New York Convention and sections 100 to 104 of the Arbitration Act. By conferring equivalence to final arbitration awards, Section 11A allows a domestic award to be converted into a domestic judgment, and you can go to the reciprocating country and register that judgment. And that is essentially what the two exceptions to Section 11 were intended to introduce. Now, secondly, in relation to this part of the legislation, and as Sir Colin Rymer stressed at paragraph 35 in his judgment, that is, again, page 59, Section 3(2)(a)(c) and Section 11A, as I've observed already, were introduced at the same time. And the significance of this, we say, is that it disposes effectively of any argument that the legislative drafter somehow overlooked the plain and unambiguous meaning and effect of Section 11A, namely that it would extend the provisions of the Gibraltar Act from court judgments to arbitral awards, denoted by the words, I quote, as they apply to a judgment, save in respect of sections 3, 5, and 8, to which I have just referred. And when one has proper regard to the exceptions in section 3, subsection 5 and 8, that uniformity of meaning and effect makes greater sense. Now, this point, together with the plain and unambiguous language of section 11A, we say effectively addresses the ROC's objection at paragraph 71 of its written case. That's electronic page 106A. Thirdly, we say that the only condition for that extension to other provisions of the Act by operation of section 11A is that the relevant arbitral award has, in pursuance of the law in force in the place where it was made, become enforceable in the same manner as a judgment given by a court in that place. This means the arbitral award must have been rendered in final and binding form in accordance with the law of the seat, namely in pursuance of the law in force in the place where it was made. As we say in our written case, at paragraph 46, that is electronic bundle page 1081, the principle at play here is parity or equivalence of court judgments and arbitral awards. The distinction in the legislation is between, on the first hand, pure interim arbitral awards, dealing, for example, with decisions on preliminary issues or interim relief, and, on the other hand, arbitral awards dealing finally with payment. And we say only the latter fall within section 11A. And we say, given the entire scheme of the Gibraltar Act, and as we've seen, it is effectively compulsory, is to permit registration of final money judgments. That requirement for equivalence between judgments and awards is entirely unsurprising. And indeed, we say it's wholly consistent with the threshold requirements for registration in section 3(2) of the Act, which equally require finality. Now, fourthly, we say there is nothing in the wording of section 3(2)(a)(c), read with section 11A, which supports the ROC's admission that either of these provisions is restricted to a recognised court and does not extend to a third country court. Section 32AC uses the broad language another country rather than recognised country or designated country. We say that is significant. Similarly, Section 11A refers in wide and neutral terms to, and I quote, the place where it, namely the arbitral award, was made, without placing any restriction on whether the seat of that arbitration is or is not a country designated under the Gibraltar Act. Now, we say that analysis, if the board accepts it, also disposes of the ROC's objection at paragraph 69 of its written case. That's Electronic Bundle 1052. Fifthly, we say, a further flaw in the ROC's analysis.
Sorry, just give me that paragraph number again in the appellant's written case.
It's 69. 1059.
So what was the point that they were making there, which you say is disposed of by this point?
The point they're making is that the language of Section 11A and Section 32AC is limited to the recognised country, so the country with whom there is reciprocity. And our point is that Section 32AC uses much broader language. It refers to another country rather than recognised country or designated country. Section 11A refers in very neutral terms, as I've submitted, to the place where the award was made, without any reference to whether that is a country with reciprocal arrangements.
So, you may be coming to this, but is the result of that a Swedish award can be enforced under this 1935 Act?
It could be directly, but not indirectly.
It could be directly.
Yes.
So it's not just that in Section 11A there is no requirement for the award to have been made in a recognised country. There's no requirement elsewhere in the Act for that to be the case. Is that your submission?
I think that is correct, but I will check that.
I mean, it's just quite surprising if it's giving a broader scope to awards than judgments.
Yes, I see.
I mean, surely this is concerned with reciprocation with certain countries and not with allowing enforcement of awards made elsewhere and non-treaty parties, non-reciprocating parties.
I take my Lord's point. I think that the point, as we understood it, was to seek, by reference to the language of those two sections, to limit to exclude the effect of this legislation, or to exclude its application to non-reciprocating countries. So when we refer to another country or the place where the award was made, we say that's Sweden on our analysis. So one isn't confined here to an analysis of only those countries which are recognised under the 1930s.
That's the point, really, isn't it? I mean, I would have thought that you read sections 3, 2 and 2A in the same way. So, I mean, they either apply to, when read with 11A, they either apply, both of them either apply to arbitration awards made anywhere in the world.
Yes.
Or only to arbitration awards made in recognised countries.
Well, in order to make sense of the exclusion, we say that read together, they must refer to arbitration awards made in...
Right, I mean, you obviously only have within the exclusion something which is within the general provision.
Of course.
Yes, of course. So that's why I say they have to be read together.
Yes.
So in a way, the question is, the first question is, as really I put to Mr. Malik, I think, what is the scope of a judgment to which this part applies under Section 4.1 when read with Section 11A?
Yes. Well,
seems to me to be quite a critical point.
Yes, so I take my Lord's point as a matter of analysis that you look at what's included before you look at what is then excluded.
Right.
But of course, here we're concerned with the judgment from England, which the cost order, and the evil, we say, that the exclusion is intended to address is that that must not be parasitic on the jurisdiction of a third country which is not a reciprocating country. That's how you read the exclusion. So whilst I accept the analytical point that you must understand what is included before what is excluded, in a sense that doesn't work as cleanly as it might in some analyses in this case, because if you are looking at an English judgment which would otherwise be registrable because it is a judgment for a sum of money, what that judgment can't be is a judgment that is in fact parasitic on a decision of a non-reciprocating country.
But it also can't be parasitic on a judgment of a reciprocating country. I thought that was the point, that 3.2 is limited to judgments of a recognised court, and I took that to mean a court of a country which is a reciprocal designated.
Yes.
Yes. So that is limited to English judgments and not Swedish judgments. Yes. But then when you get to the court of another country, in 3.2ab or 3.2ac, I thought it was common ground that could be either a recognised court or a non-recognised.
Or a non-recognised court. And my lady, that's right. I would accept that. And we say that is consistent. Assuming for present analysis, it's a recognised court in that third country.
Yes.
We say that's entirely consistent with the policy of avoiding parasitic judgments, because the reciprocating country party can come to Gibraltar directly. That's the whole point of the Act. And indeed, under the Act, they must come under the Act. They cannot come any other way.
Right. So suppose France was another recognised country. So if you had an arbitral award which was, you say, recognised as a judgment in France, you could come directly to Gibraltar and try and enforce that.
Yes.
But if you then went and got it registered in England, you would still, I think you say, not be able to get that English judgment registered. They would say, no, bring the French judgment and we'll register that.
Yes.
Right.
That is our submission.
And so that points to the aim of this not so much being to avoid judgment laundering, because French judgment is perfectly non-laundered, whatever, perfectly acceptable. And, but it then points to actually the reason being because you've got to be able to look at why the French court did what it did or decided what it did, and whether that was...
Yes, and I don't think Mr. Mallet was criticising me when he said I hadn't used the term judgment laundering in my submission. That was entirely deliberate. Not only is it a slightly pejorative term, but in our submission it's not very helpful because it applies in circumstances where there is a real concern about the originating jurisdiction. There may be other entirely justified and proper policy reasons why judgments on judgments should not be enforced, which have nothing to do with cynical laundering of those judgments. And this is one such case where the Gibraltar Parliament, as it now is, decided to apply a statutory regime, an exclusive statutory regime for the registration of judgments in its jurisdiction, which must be with reciprocating countries and must not be based in any way on the jurisdiction of a third country, whether reciprocating or not.
You can't use the reciprocating country as a springboard, as it were, to enforce a judgment with a third
You can't.
country.
That's it. And there is nothing remotely absurd or unintended or unusual, we say, about that. It's a perfectly coherent, juridically coherent way of approaching the registration of foreign judgments and awards.
There we are. Well,
I'm conscious of the time, having promised coming on time. I've overstepped into lunch, so I apologise. If we break there, and I will come back to that and a couple of the new points that were raised in the course of submission in relation to section 11A.
we'll resume them at 2 o'clock. Thank you very much.